call. Darian Fenton.
Thank you, Mr Speaker. Well, I do rise to speak on this bill with a very heavy heart, and I want to say that my thoughts and solidarity are with the Pike River miners, their families, their workmates and their fellow union members, and of course the Greymouth community. While we are focused on getting the miners out safely, this tragedy has much wider impacts. The workers of Pike River Coalmen who are wondering if they'll have a job in the future, those who weren't in the mine, who now face real uncertainty about their employment, the children and families of other miners in other mines who are now fearful about their family members, their sons and fathers going to work, the search and rescue workers. It must be incredibly frustrating for them and their families. Mr Speaker, I want to say an accident like this shames us all, and there will be a time for questions once the recovery of the miners is completed. This is a terrible time for all involved, and it won't be quickly forgotten. So I can't understand why the government would think it was appropriate to have this and the next Employment Relations Bill in the House today. I believe it's pretty crass and it's a thoughtless decision to have the third and final stages of these bills, which, whether the government admits it or not, are stripping away workers' rights. I can only think because this government doesn't really appreciate the contribution and sometimes the terrible sacrifice that workers make in playing their part in our businesses and in the economy. Mr Speaker, this bill is a backward step in New Zealand employment relations. The government has failed to make the case that any parts of this bill, and particularly access the 90-day trial provision extension and the changes to personal grievances, are needed. The Minister's own department, the Department of Labour, raised real questions about the necessity of any of these measures, and the Treasury, even though they supported it in principle, said there was a real lack of robust evidence. This is bad lawmaking. This is bad lawmaking when you rush into something on a whim of an idea without the proper research, without the background. Thousands of submitters expressed opposition to this bill, but they were ignored. 22,000 workers marched and rallied, and John Key shrugged. Professor Erling Rasmussen of Auckland University of Technology says that New Zealand is now, under this bill, one step closer to an American hire and fire model, and he says that it's difficult to see how this will improve the productive employment relationships of well-organised employers. He says this appears to be a clear hand-up for disorganised, incompetent employers. This is not just a whittling away of employee rights. It heralds a fundamental shift in employer-employee relationships in New Zealand workplaces. He goes on to say this is not a trivial change to employment relations. Even under the Employment Contracts Act, the hated Employment Contracts Act of the 90s, this was not a feasible option for low-paying, high-turnover employees. So, even the professionals are questioning this. The Minister, I noticed in his speech, calls opposition to the 90-day trial periods and other things hysterical. I think that's incredibly insulting. I find that incredibly insulting when, as I said before, the Minister's own research, the Department's research on the 90-day extension to the trial period was highly flawed. They managed to speak to 3,000 employers, but just 13 workers. And even then, they failed to demonstrate that those that the government was claiming would benefit from that provision, the previous law, such as migrants and Pacifica and Māori and young workers, have actually been given jobs that they would not have otherwise been given. One of the first workers to take a case under this bill, Heather Smith, a pharmacy worker, she's called on Parliament to spare other workers the experience that she suffered under the 90-day fire at will law. She's made the call as we go through the third reading, and what she's saying is, I don't want to see what was done to me happen for many more vulnerable workers in their first 90 days on the job. I was fortunate that the employer in my case made a mistake and enabled me to take a case, but if they'd done everything according to the 90-day law, in other words, Mr Speaker, if they'd got the paperwork right, I would have had no opportunity to question my sacking. no opportunity. And just consider for a moment what impact that has on a young worker like Heather Smith. Not allowed to question why she got the sack, will never know the reason. Every job she goes to from then on, there will be a question on her curriculum vitae, what happened in that period when she was working, because she was with that employer for some time. People, people who get fired under this have an ongoing impact on their life. We are talking about, under this bill, real people and real examples. And the fact is that this law will impact on the most vulnerable, those who are least able to question their employer, those who are low paid, those who are actually people who've been on a benefit, who've been sent down to a job by work and income, who cannot turn it down. And that's been confirmed by the Minister and the Minister for Social Development and Employment. They cannot turn it down because a job with a 90-day period is treated like any other job. If they turn it down, they get stood down from their unemployment benefit. Now, the Minister talked again about choice and saying it was voluntary. What choice does a worker in that situation have? How can that be voluntary? How can that be voluntary? That is ridiculous. That is utterly ridiculous. And as I said, Mr Speaker, the government has completely failed to make their case. The provisions around the extension of the 90-day trial period are simply unjustified. And we know that the only reason that they're being extended to all workplaces is because the Minister got rolled by the ACT Party. That's what happened. The Minister got rolled by the ACT Party. Now, I want to turn to access and the provisions around access. And the Minister's right, these two provisions have had a lot of attention, but that doesn't mean there are not a lot of other concerns with this bill. And if I have time, I will go on to those. But I want to talk about what happens with access at the moment. The current law is very specific about the requirements of a union organiser or representative going into a work site. There are a number of things they have to follow through. Those provisions in the Employment Relations Act came about from case law that was developed under the Employment Contracts Act, which is why people are fearful about this provision, Mr Speaker, because actually, under the Employment Contracts Act, it wasn't nearly as strict as this. Yet there was terrible trouble. There were court cases up and down the country. I was part of one of a hotel employer who said that unions were like interfering mothers-in-law and as such should never be allowed in the workplace. And he used to go about and say, who wants to see the union, put their names up on the notice board, and then when the union organiser came and put them in a room, call people along one by one, people who were fearful for their jobs, worried about their jobs, and expose them in that way and give the message that the union was not welcome on the job. That's why people are nervous about access. I'm also interested in the whole provision in access around health and safety and why the Minister decided, even though she had a draft cabinet paper that was provided to her on the 11th of August by the Department of Labour, that access consent would not be required in situations of health and safety. Now, we've heard the example from my colleague Trevor Mallard about a worker being sexually harassed, but what about a situation of health and safety where a union representative is required on the job to come and deal with a situation where something's urgent, something needs to be dealt with? So, Mr Speaker, as I said, there are many other things. If I had the chance, I would talk about. I'm concerned about the changes to the test of justification. I'm concerned about things like the removal of reinstatement as a primary remedy. Clearly, I don't have time to go into those, but they are concerns. This bill is so badly done, it will create a lawyer's charter, and that we will pay the price on this for years to come.